that we are. Okay, tonight's live stream is going to be amazing. This is the second installment of Saturday Night Live Stream with Viva and Nate. Tonight, we're going to be reading through the Veronica Brill lawsuit against Mike Postle, the Stones gambling hall, casino, whatever. We're going to be reading through that lawsuit because I've done a video on the subject in the past few days, and that was breaking down the situation that was going on. I have since, thanks to Stuart Hughes, the North or South Dakota lawyer, he's a Dakota lawyer, we've gotten a copy of the proceedings. I sent it to the other YouTube lawyer that I've become friends with to do a live stream. We're going to go through it. We're going to discuss it. We're going to analyze it because there have been a ton of live streams on this particular subject. First of all, Joe Ingram won. If nobody knows who he is and if you're into poker, go check out his live streams on the subject. You'll learn a lot and you're going to laugh a lot because he's got quite a good sense of humor. We're going to go through it tonight, and we're going to go through it, and hopefully this is going to be entertaining, and not hopefully. This is going to be entertaining and insightful. So we'll give a few minutes for everybody to come in. If you could, everyone who's watching this now, tweet out the link, invite some people to get in on this, and hopefully, people are going to start tuning in because this has the best of everything. This has Hollywood movie in it. This has poker, gambling, accusations of cheating, lawsuits. It's got everything. It's got everything, and you're going to learn about the law. Now, Nate Broady, for all of those who don't yet know who he is, he's a New York lawyer. We've done a live stream where we got to know everything about Nate Lawyer as a human. That's the first live stream. We've done, I want to say, one or two other live streams since. But Nate is a New York lawyer. He is tremendously smart, tremendously well-informed, and I want to say basically one of my go-to people in terms of getting legal information. So we got Alan Milland in the house, Tony Nieves. I know we got Josue Veguia. We got TX Packet. What's the standard? I'm going to give the standard disclaimer when Nate gets in here, but this is a live stream. Pace is different. I'm going to try to get to all of the comments if I can. If there's super chat, I'm going to try to get to all, I'm going to get to all the super chat, hell or high water. So, but it is a different pace. So if you're used to the standard Viva Frei 10 to 20 minute lightning blitzkrieg vlog, this is going to be maybe just as fast paced, but might be more meandering. It's topic oriented. And tonight, we're doing Veronica Brill lawsuit against Mike Postle and Stones Casino and Curatus, John Curatus. It's a poker scandal that has rocked the Sacramento, California poker community. All right, bringing in Nate. I see him smiling. Let's do this here. Boom, Nate.
Hey, what's going on? How's everybody doing out there?
This is going to be amazing. The amazing thing is it's 6 o'clock in Vegas, so we know we're going to have a lot of people never eat straight away. West Coast who are going to tune in for this.
Hey, listen, you didn't read my super chat. I got sent a super chat in.
Why would you send a super chat in?
Because you said you're going to read super chat, so I said I'll send a super chat just to make it seem great. What's going on?
Yeah, I haven't seen it. Wait, there it is. Nate Broady from Nate Broady. Post, baby. And this is the funny thing. Like my wife said to me, 10 years ago, I would have been dying to play poker on a Saturday night. And now we're doing poker themed live streams on a Saturday night. Nate, I dare say we've become total losers in life, but
yeah.
the loser now is the winner at the end, I guess. So what was I going to say? Okay, standard disclaimer. First of all, nothing in here is legal advice. Nate?
Yes, please. This is if you're getting legal advice from this stream, you have bigger problems than you really have. So go to a lawyer in your area and speak to them. Somebody licensed to practice law in your area. So
you may get insight, you may get knowledge, and you will certainly get entertainment. But this is not legal advice. So don't say, "Well, I saw it on YouTube and Viva Frei said X or Nate Broady said Y, and therefore I'm suing."
Oh my God.
And this is the other caveat. We may be wrong. Like I have a bit of a problem where I'm a glutton for punishment and I go read all the comments and I read all the comments where people say how wrong I was and I got this. We're going to be wrong. I mean, I'm going to be wrong. Nate might be wrong. The goal here is not infallibility. It is exploring, discussing, learning, and with the liberty of being wrong. Someone tell me if I'm yelling too much.
You got another super chat from James Watt.
James Watt. Where? Hold on. Let me see this. See, we're using StreamYard and it's phenomenal. The only problem is the The comments and the super chat are not so easy to distinguish. James Watts says, "Love your vlogs, family and pets. Keep up the great, entertaining work." Thank you very much, James. I will do my best to be able to do it. The dogs, full disclosure, have been driving me nuts. One of them whines all the time, and the other one has not been behaving properly with other members of the family. So we're going to have to, anyhow. Yeah, Vlog Dog needs some serious training, but. Okay, so that's it. We're going to discuss this. Nate is the U.S. lawyer who's going to be able to really shed some insight into this. And it's the stuff that movies are made of. It's going to be amazing. We've got Jeremiah Halpin says, I have been watching all of the videos on Mike Postle, the Apostle. we're going to get into it, but I got stuck watching like Joe Ingram's 5-hour live streams. I watch them at 2 times the speed. Yeah. The dude should work for the CIA or the FBI because admittedly he's got a lot of help from other people on the internet. Like, everybody's sending him the most suspicious stuff. And so you get to like siphon out the knowledge. It's amazing. Yes. It's one thing I do like is that he always loved. I love the way he like is analyzing every single move this guy makes. This guy scratches his nose. He's like, "That's a tell. That's a tell. He should know." I would say the most interesting tells are the what I think is like this, which we'll get into, and this and the hat, which we'll get into. But now, what I did want to say, because I probably could have been more explicit about it in my first video. Mike Postle is innocent until proven guilty. And I don't want to say that. I'm not saying that just tongue in cheek, like innocent until proven guilty. Now let's go bash him for 3 or however many hours this live stream lasts. He is innocent until proven guilty. And the reality is that the accusations, and we're going to get into it, are all circumstantial, which is not to undermine the seriousness of them, but they are circumstantial in the sense that they're based on statistics and not hard evidence. Yes. I know what I believe, and what I believe doesn't matter. But full disclosure, like I've watched enough to know that it's not normal poker play. But the reality is that nonetheless, all of the accusations are based on statistical probabilities and reading body language, and not any hard evidence smoking gun. So there's that. Innocent until proven guilty, and I, this should not be seen as part of like a pouncing on Mike Postle, who is obviously not in the best of worlds right now. And the second caveat to that is, even if he is guilty, there is still a part of me that feels bad for anybody who would have to resort to this. And I can only imagine the reasons why anybody might have to decide to resorting to this type of chicanery in life to make ends meet. So that's the caveat. And with that, I think we've been rolling for 7 minutes. Let's get into the suit. Nate, do you have anything you want to add? Well, I want to ask if there's any poker played. Anybody out there played a Cadillac of poker? Because that's Texas. That's what he's playing. Well, I think he was playing Omaha too. But No Limit, Texas Hold'em. It was Texas No Limit, and then I think they rotated when they had like some certain types of games to Pot Limit Omaha. Yeah, he was winning them all. 94%. Like a 90 for those of you out there, a 94% win rate in poker. That's amazing. It's phenomenal stuff. Some people were commenting on my video where I showed the graph of the lump of blue dots. It didn't even capture Mike Postle's red dot off the charts. And so people were like, yeah, it's a statistical, it's not an anomaly, because an anomaly is something that is, that occurs, that is inexplicable. It's a statistical improbability. It's just not possible. And it's not possible in the way that it was done. But we've got Alan Milland, who says he's been playing poker for 20 years. It's funny, man. Like I've been watching poker since early 2000s. It's close to 20 years now. Okay, so that's it. We're going to go through the lawsuit now. For anybody, I should set the context. For anybody who doesn't know what's going on, Mike Postle has been a relatively, I don't want to call him a no-name in an insulting way, but he's not been anybody that has been big on the poker scene in high stakes or a world-renowned poker player. He won something in the order of, arguably, depending on who you ask, $250,000 to $300,000 profit playing relatively low stakes poker, anywhere between 1 and 3 limit and 2 and 5. They called it bomb pots bloated poker, but basically the pots got bigger. But he won $250,000 to $300,000 over the course of a year, strictly playing on the live stream poker table at a place called Stone's Gambling Hall, which was created in 2014. Now, why that's relevant, that he made all of his money only playing the live stream, is that the live stream poker cards have what's called an RFID technology, radio frequency identification. And people were noticing he'd only win playing the live stream. He'd stop playing when the live stream was over and not play the live game that was offline. And people began drawing their conclusions after someone came out and accused them. And so I guess what happened is a poker employee at the place, her name is Veronica Brill, came out and publicly accused him of cheating. And then the internet, let's call them the internet poker community, unleashed, what do they call it in the lawsuit? An ad hoc investigation.
Yeah.
The
power of the internet.
Yeah, the ad hoc investigation, meaning unelected, unnominated, unappointed experts now put together an expert investigation which rivals anything the intelligence community could have ever done. And they went over 200 hours of poker play and found like it was just impossible. It's impossible. And so the discussion is whether or not it was reading or intercepting the RFID technology chips, whether or not there was a bone conductor, something in his hat that was, someone was talking to him, telling him who had what. Okay, nobody knows how he was cheating. Nobody knows definitively if he was cheating. It is just accusations based on statistical, inexplicable results.
Yes.
Good enough?
But one thing that's very interesting is that, and this is something I didn't know until I was reading through the lawsuit, is the fact that, if you guys ever watched the World Series of Poker and those poker shows, when they do the commentary is actually done on a half-hour time delay, so that you won't have that cheating. So because they'll actually see the cards, so there's like a time delay between the commentators and the play. But at this casino, there was less of that delay, right? There wasn't that huge delay.
There was a 30-minute delay, but apparently from the lawsuit, what they said was that the live commentators were actually in the same physical structure, not far from the table. Okay. So whereas typically when they do the whatever delay they have, the commentators are off-site, which in theory makes it more difficult to cheat. I'm not sure I believe that, because I think you can have people call in from the booth, whatever. But that's one of the things we'll get into in the lawsuit. So that is how did Siri?
One moment. I don't know.
Yeah, I wasn't talking to Siri. My apologies.
She's listening. She's listening now.
She's listening so well. I must have said something that rhymes enough with Siri. So I mean, okay, now we've got everybody coming with some theories here. So let's get to the lawsuit. We'll get that out of the way so we can really get into this discussion. I'm going to bring up the PDF, which requires me to share the screen, go to the application, bring this up, and hit share. And now, does everyone see this?
It's loading up. It's loading. Boom! It's there.
How beautiful is this technology? And I can still see the comments, so I can get to every question if we've got them. If I miss any super chat, if I miss any, I don't want to say good versus bad question. If I miss something, someone bring it up to my attention. And let us, on a Saturday night, live read a lawsuit. Okay, first thing, Nate, explain to people who are not lawyers what we are looking at. Do you see my cursor by any chance or no?
Yes, I see it. Okay. I see your cursor. Yeah.
Sweet. Explain to us what we see here, everything, all of this information. There's a lot of info there.
Well, on the left side is just the who's suing, the plaintiffs and the defendants. So you'll see the named plaintiffs. I'm surprised it doesn't say et al. Usually you'll have either the main plaintiff and et al, or you'll have a list of the names. And then you'll see on the bottom is the defendants. And the defendants is Mike Postle. You'll also see something down here where it says John Doe's. John Doe's is that you're saying that there are more people involved. You just don't know who they are. So you'll sue John Doe, and then if you find out who they are, then you'll bring them into the lawsuit. So that's what it means. It's saying I'm suing these people, but there are more people involved. I don't know who they are. So John, and you'll see Jane Doe's. John for guys, Jane for females. On the other side, you'll see the complaint and demand for a trial. So this is just announcing what this document is. And then you'll see here, we don't do this where I'm at, where you list the cause of actions in the caption, but here they list the cause of action, so they tell you exactly what we're suing for. The first cause of action, the violation of the RICO statute, the Racketeering Influence Corruption Organization, that's a federal statute that they're saying they're violating, a federal civil statute they're suing under, and then numbers 2 through 9 are actually state tortious laws, state tort violations that they're suing under. So here you have a complaint that has a federal crime on top. The first one is a federal violation, and then the next, next 8 are actually state claims.
Okay, so now top 2 are federal. The top first one is federal. Okay, and so for anybody who doesn't know what you're talking about right now, explain that in a little more detail.
All right. Well, yeah, what I mean by federal course of action is that since and the federal government, this RICO violation is actually a statute or a law passed by Congress. So if you violate that, it's a federal cause of action. But the number 2 through 9 are the state of California. Those are laws that are passed in the state of California, this lawsuit is saying this person violated this civil penalty in the federal system, and also violated all of these tortious acts on the state level. So that's what you have. You have a federal cause of action, and you have all these state causes of action. Okay, that's very interesting. Now, and I had done a video on this in terms of Justice Smollett, very briefly explaining the differences between federal court and state court and why one might prefer one over the other. So there's that video if anybody wants to go back to it. But offhand, Nate, I mean, can you list some of the reasons why someone might want to be before a federal trial by jury as opposed to a state trial by jury? Well, I think in this case, sometimes it's easier to win your case in federal court, and plus, I think you want to get that racketeering charge. That I think they get you a little bit more money. I think that's where they're going for the bulk of what we're talking about. But generally, if you have people from different states and all this other stuff, you just rather be in federal court than in state court. But it really all depends on the cause of action. Sometimes it's preferable to be in a state court than a federal court. But here I think, because first, let me just talk about, we'll get to the venue. But first, I think in this particular cause of action, it seems like since you have people from Canada, like when we go through actually who's suing, you'll see people from Canada, you'll see people from all across the country. And I think it's just easier to sue in federal court than it would be to sue in state court, because then you don't want to have the defendant play the game where, well, we have diversity jurisdiction where I have a citizen from another state, so I can bring it to federal court anyway, and then you have to start the whole process over again. I think I explained that poorly, but that's kind of it's a tool that you can use. No, so I understand, and also not to redo what I mentioned in the other video where when it's some detail about the difference between state and federal trial, but that is interesting. So if you have interstate or out of country plaintiffs, if you filed in state, then in theory, the defendant can make a motion to change jurisdiction, and then you're just wasting time getting bumped up to the proper jurisdiction. So this saves that potential unnecessary argument. Correct. Yeah, correct. It could be, it's called diversity jurisdiction here, where if I'm suing somebody from a different state, I can sue them in state court, but then they can actually, if it's above $75,000, which this is, they can then remove it to federal court saying, oh, we're going to remove the federal court because we're diverse. And this also has a federal question, which is that first cause of action. So you can get it removed to federal court too, based on the cause of action. So here you're just saying, I don't want to go through that step with filing in the state, and then you try to play that game. We're just going to file in the federal court. Okay, very interesting. And now, I'm looking at the names. I'm curious if anybody in the comment section knows who any of these poker players are, because presumably they are all poker players. Not to go through all of them. Casey Lynn Mills, Mark Goon, Navroop Shergill. There's a lot of people suing. And the defendants, we have Michael Postle, King's Casino LLC, doing business as Stone's Gambling Hall, Justin F. Curatus, who was the tournament director, from what I understand. And then we have the John Does and Jane Does 1 through 10, who are as of yet unnamed. Okay, so let's just go through this wonderful poetry that is a lawsuit. We don't need to get into it, but come now, Veronica Brill, and then we go through all of the plaintiffs. And where do we get to the defendant part here? It doesn't really matter, but introduction is plaintiffs suing the defendants. They state as follows in their suit. This case concerns Mr. Postle's systematic use of one or more electronic devices for purposes of cheating while playing in broadcast games of poker to steal hundreds of thousands of dollars from fellow players. One caveat here is to illustrate why this is such an egregious crime, is that it's not like stealing from a casino or stealing from a bank where people can sort of empathize and almost approve of. There's like a camaraderie in poker that this violates the most fundamental rule of not stealing and not cheating from your fellow players, which is the worst insults any poker player can get is that they're cheating. But it's an interesting way of just phrasing the first paragraph, which they're moralizing the theft. It's not like you just stole from a casino. It's you stole from other fellow poker players, and that's like the biggest no-no that you can do. We can skip this we'll go through it very quickly. All poker games occurred at Stone's eponymous facility in Citrus Heights, California.
And we get interesting stuff here. Paragraph 3, when Miss Brill made public her concerns of cheating in late September 2019, Stones initially responded by indicating her observations to be completely fabricated. Only after the ad hoc poker community proceeded to investigate such allegations in a myriad of public forums and confirmed Mr. Postle to be engaged in demonstrative cheating, did Stones announce a new investigation to be underway by an, quote, independent third party, who is actually Stone's own legal counsel. This is just the interesting way that it actually went down. Is it's when the poker community put together all of these outlandish hands and anomalies that apparently Stones decided to go back and reinvestigate themselves, who they had previously exonerated. Okay, as extrapolated upon infra, what infra means going down inside the lawsuit, right?
Yes.
The case represents the single largest known cheating scandal in the history of poker, emanates from a series of events that have rocked the poker community, is brought with the hopes the discovery process will reveal why Stones appears to have perpetually covered up for Mr. Postle, and is filed with the aim of bringing redress to the numerous individuals victimized in herein. This is the amazing thing, and they mentioned it later on, and we'll get to it. They emphasize that there's no hard evidence, that this is based on statistics, and they're going to hope through the discovery process, presumably either to strengthen their initial claims or find, the smoking gun hard evidence that will better support the claim. And Nate, we'll get into this later, but the question is whether or not the, call it circumstantial statistical evidence they have is sufficiently strong, not even necessarily to win, but to maintain the claim and to have it stand up potentially against a motion to dismiss. And so I skipped a lot here. These are all the parties. We don't need to really go through that.
But you can see some of them for different countries, different states. You can see it. It's crazy.
Yeah, we got Casper's California. There seems a lot of California, Missouri. And there's a variety of plaintiffs. John Doe's 1 through 10 and Jane Doe's 1 through 10, who are persons who conspired with Mr. Postle to cheat at the game. I hope I'm not going too fast, incidentally. Through one or more electronic instrumentalities. Yes. Sorry, go ahead.
No, and this is that, we believe other people are helping and we believe they use something, but we just don't know. So we're just going to name it. And again, they're hoping through the discovery process that they can find out who these people are, if these people even exist.
And it's a question that I had asked you, Nate, before we got started, but to the extent that they do find additional defendants later on, they have to amend and refile the entire lawsuit against those additional defendants with all of the delays that would otherwise apply starting anew?
Yeah, but you'd have to, because you'd have to give them that due process time. You'd have to give them time to respond. They may want to file a motion to dismiss. They may say, so you'd have to give them all those, all that process so they can actually catch up, because it just wouldn't be fair to just bring them into the middle of the lawsuit and say, well, we're suing you now because we couldn't find you. You know what I'm saying? They have to have that time to file an answer and a response and say, hey, I'm motion to dismiss. I wasn't even involved. You'd still have to give them that due process.
Okay, that's very interesting. Okay, let's skip to jurisdiction and venue. I mean, we don't. This is where they allege why the courts have jurisdiction. The amount. Yeah.
Now, this is an interesting learning tool, because we're talking about this is what happens is in the United States, the federal courts or courts of what they call limited jurisdiction. So they can only hear certain cases. They can only hear cases involving federal questions, that's federal statutes or the U.S. Constitution, or they can hear cases what they call in diversity jurisdiction, like we were talking about earlier. Here, this is a federal question. They have one of their claims is actually a federal law. They're saying under federal law, these people have harmed us. But now they also have some state claims. So for efficiency, the judicial system, you'll see a term in there called supplemental jurisdiction, in terms of, okay, since we have this federal question, we'll let you also litigate your state claims in federal court, so you can dispose of them all together in one. So that's what they're doing here. They're saying you have this federal question that we're going to resolve because it's for federal court, and your state claims are going to resolve for judicial efficiency.
Okay, very interesting. And if anybody sees me looking down to the left, I've noted paragraphs that I want to make sure not to miss, because they are the most relevant in terms of the claim itself. Okay, so the damages exceed $5 million. Should there be an infirmity in the federal question raised herein, the plaintiffs are prepared to amend this complaint to assert their claims on behalf of themselves and all others similarly situated, and thus invoke this honorable court's jurisdiction pursuant to the allowances of section whatever. So I think I understand this, but that basically means if the federal court loses jurisdiction, then they're prepared to amend and submit to the state court.
Yeah, this isn't the same thing that happened in the PragerU case. They lost their federal claim and they went right to the state, and they said, "Well, go to the state court because you still have state claims that can be sorted out."
Okay, very cool. So now, general allegations. Nate, you've seen a lot of lawsuits. Is this drafted relatively well? Is this drafted relatively standard, or is it above average or below average, in your respectful opinion?
To be honest with you, I've never seen one of these RICO cases, but the way it's drafted, it seems well, but it's like, I don't know how to explain it. It doesn't. I don't feel it tells me enough. I feel like, you know, the other side can reasonably have a good motion to dismiss here based on what I'm reading here. But again, I just don't know. I'm just not confident in it because, again, I've never seen this for this court of action, and this is a California case. So,
okay. All right, so the general allegations, the poker casino open. Incidentally, people, this is how lawsuits are generally drafted. You set up the parties, you establish jurisdiction, and then you tell your story. And your story starts from the beginning and ideally goes chronologically or at least logically. So right now they're talking about the casino, what the casino did, paragraph 39, as a means of promoting the casino, attracting more lucrative poker games to the casino, and giving the casino the aura and ambiance of a destination. Stones installed a single poker table. This is important, incidentally.
Yes, this is
a single poker table embedded with RFID capabilities, procured playing cards containing RFID sensors, and installed various motion picture cameras around the poker table, the RFID table. Stones installed one RFID, one live streaming poker table that would only go live at certain times.
Yes.
And all of the action is going to basically surround this one particular table.
And remember, this is the only place this guy played, right? He didn't play at the other tables. Like, this was the only place he played when it was active, right?
He may have played at the other tables, and he may have either broken even or lost when he did. This is where he made all the money when he did play, and you know, did not play as much offline once the specific RFID table went offline.
And also, one thing that we forgot to mention with the parties, the casino was actually as a name defendant in this case too. Yeah,
the casino, the employee, the curatus, who's the employee, tournament manager, and Mike Postle, and 20 other Jane Does, John Does. Okay, so while games of poker are traditionally played in a manner that at least some of each respective player's cards are concealed for everyone except that individual player, the whole cards, they're summarizing what poker is for those who don't really know it. The RFID table introduced the ability of Stones to transmit in real time the identity of each player's hold cards to a control room where such information can be utilized to produce the broadcast of the subject poker game. So basically, like during the live stream, the graph needs to know what everybody's cards are. And in order to get that information, there's a live feed that transmits the RFID to the control room. There's a delay, but the feed itself is live. So that's basically what they're explaining here. We get into some history of the RFID. Other casinos have used it, and I guess this is relevant to establish a certain industry standard in terms of security as to what other poker casinos are doing to ensure the security of these live stream RFID enabled cards versus what Stones did or did not do.
But this is important to the negligence claim too, because this is saying that they had a duty of care, and they're saying that this is that this procedure, the way the security is set up on these things, the casino, by not doing it correctly, breached that duty of care. They owed them a duty of care, saying, "Hey, this is going to be fair. This is, we've taken all precautions," and the fact that other places have done this and never had this problem shows that they violated the duty of care to the plaintiff.
Yeah, and if we go to paragraph 43, it says other operators of RFID-enabled poker games, such as the WSOP, Bicycles Casino, take extensive steps to ensure the security of players' hold cards so as to protect the integrity of the poker games being broadcast, to entice reputable poker players to participate in such games, and to avoid enabling the sort of rampant criminality alleged in this complaint. Now, and this is getting back to some of the criticism that I received from my video, which was that I'm operating on the conclusion that he cheated, which is a fair critique, because in my mind, I've seen it. I know I've seen his body language. I've seen the results, and I know poker. I think he did. The problem is this entire lawsuit is premised, and you can see it here. They're taking for granted that there was cheating. They don't know how, but it had to have been through some sort of weakness in the RFID encryption or security. And so they're basically, unfortunately, basing their argument off of the conclusion that they've already drawn, that he was in fact cheating. And you can see the evidentiary burden that they're going to have, which they're saying they didn't take steps to secure the players' hold cards. even though we have no evidence that they didn't, except for the fact that we think he was cheating because of his success rate. And so it's sort of like a vicious circle or a dog chasing his tail. But
it's an inference built on an inference built on an inference. Yeah, the inference that he was cheating, the inference that he could see our hold card, the inference that he could, it's all tenuous at best.
Yeah, they've come to the conclusion that the casino did not secure the cards because they've already come to the conclusion that he was cheating and that the casino was not protecting the cards. And it's and people were asking in the comment section and on other live streams, like, the burden of proof civilly versus criminally, where, I mean, Nate, you can feel this one, like,
this is just a preponderance of the evidence. So, but it's interesting because in each one of these courts of action, there are certain elements that have to be met. Sometimes there are 5 or 6 elements. And when you're trying to go through these elements, you have to prove each one by a preponderance of the evidence. And if you don't prove one of the elements by a preponderance of the evidence, then you've lost that course of action.
Now, incidentally, if anyone can tell me, when I bring up this comment now, I can't see my screen. You can see it? Okay, awesome. Yeah, so the argument is it's not just because of his success rate, and there's a number of other indications, which we'll get to. Paragraph 46 to 49, I had flagged. Okay, here we go. Actually, we might want to get into it at paragraph 45. When Stone utilizes its RFID table to broadcast poker games, it has one or more persons offer live commentary on the subject game from a booth within the Stone's poker room. The commentator defined here, which is itself interesting. Like, they have people in the actual casino commenting live, although there's a 30-minute delay, but they get live information. Oh, no, they don't get the live information. It's delayed by 30 minutes. It's delayed,
yeah,
even to the commentators, but they're within the same building, which I guess means that there's sort of a direct feed from the table to the same building to transmit that information. Paragraph 46 is the commentator does not view RFID information and players' hold cards in real time, but rather watches the produced stream on the same tape delay as the public and commentates by watching the already produced visual stream. Stone's live poker operated from at least January 2016 until the week prior to the bringing of this complaint, when the operation was suspended in light of the scandal giving rise to this case. And then they say, now, this is relevant just to establish who should be responsible for the actions alleged against the defendant. At all relevant times, Stone's live poker has been controlled en toto by Stone's and its agents from at least 2018 to the present. Mr. Curatus, an employee of Stone's, has been the director of the Stone's live poker and has been responsible for its production and security. So they're basically just saying that Stone's, whoever operated the poker stream, was under the control of Stone's, the casino, so they can go after Stone's and not any other party. Nate, have you got anything to add?
Well, right now, just based on this, I don't see, especially for the first course of action, how they're going to tie in this player with the casino, because they've not, and maybe they'll say it soon, but they haven't made that connection where him and the casino are working together in kind of this enterprise to kind of defraud them. They're saying this happened. They're saying there's a flaw in the system, but they're not saying how the casino really was working with this player to produce this result.
Yeah, as in to say that the casino could have failed in its obligations towards its patrons, but not necessarily be working or conspiring with Postle to defraud. So Postle could have just seen a weakness and exploited it, and the plaintiffs are not necessarily making the connection of collusion between the two.
Correct.
Okay, so let's see here. We got Mr. Postle's wins on the Stone's live poker broadcast and its correlative play in poker have been so exceptionally outstanding as to lead the commentator to note his seemingly mystical abilities on numerous occasions, and to lead Stone's is that a typo? That is a typo. Stone's live poker to produce various graphics portraying Mr. Postle as a deity-like individual imbued with omniscient powers. If anyone hasn't seen this, with one such graphic conflating an image of Mr. Postle and an image of Jesus. And then, I mean, I've seen it. It was ridiculous. It was sort of ridiculous in terms of the commentators actually, their reactions. But then, when you think that he's cheating and when you think that he had to have cheated, you begin to retrospectively judge everyone else's conduct accordingly. So it's sort of arguing from a conclusion and not towards one. But this is when they discussed the statistical impossibility of his win rate. The optimal decision making was so precise as to allow Mr. Postle to record net winnings in more than 94% of the Stone's live poker games in which he played from July 18th, 2018 onward. So like over a year. Games are of fixed duration and elevated variance relative to normal poker games. Such winning percentage under these confined circumstances in a streamed environment is not known to have ever been achieved by any other poker player, professional or amateur, over such a significant period of time.
But one thing I'd stop is that here, that's a good argument, but they should have. I think here in the complaint, this is where maybe they failed. They should have showed some type of context. In other words, like Ken Jennings, for instance, the before Ken Jennings, no one had won over 20 games in a row for Jeopardy. I think it was like, no, actually, I think it was 15. Then he came and won like 74 in a row. You know, that would be a statistical anomaly. And then after that, I think some guy won 20 after that. So you know, these things do happen, but don't get me wrong, 94% over a year and a half. I play poker. That is insane. That's like hitting a lotto 3 times in a row. No, it's crazy.
It's like getting struck by lightning every day of your life for. But with Ken Jennings, and for anybody who doesn't know, Ken Jennings was the most winningest participant on Jeopardy. Nobody accused him of cheating, right?
No.
Okay. And the funny thing is, like, you assume that when someone's on Jeopardy, they're not wearing hats, they're not like looking at their cell phone, they're not staring at their crotch. You sort of assume they've gone through some sort of security, whereas, or at least I do, maybe I'm making assumptions, but whereas in a casino, they're wearing hats and they're looking on their cell phones, and you sort of take for granted that they can't be cheating because it would be impossible based on the security of the casino. If I had seen Ken Jennings doing this and like looking down before getting every right answer, people might have started asking questions. It's just you start with a certain base level of presumptions, with a talk show like Jeopardy. But yeah, I mean, this entire claim is based strictly on the statistics, not on any hard evidence yet. And if they get to a discovery process, maybe they'll find it. My concern now, in having read it, is they might. If it gets dismissed before they even get the benefit of discovery. Paragraph 56, a detailed review of Mr. Postle's play reveals not only statistics unfathomable in the professional world of poker, but too often situation-specific decision-making in which almost every so-called guess to be made by Mr. Postle is done so in a manner that optimally benefits his monetary interests. And for anybody who doesn't play poker that might still be watching this stream, what that means is he's not just winning on Showdown. He is knowing the situation, making bets and choosing a course of action in which he doesn't necessarily have the best hand, but in which, if you knew the other player's hole cards, that's what you would do to get them off the hand that you knew they had, because they wouldn't be able to play it any other way. And that's what really raised a lot of flags for a lot of the poker community.
It's like you flop off straight, and the guy gets like a full house on the river, and it would be like the one card, the million that he would get, and this guy would probably, everybody else would be busted out of that hand, and this guy's folding it.
It wasn't quite as egregious as a boat over a straight, but there was one commentator who pointed out, I think he folded top pair to a bet on the turn, like it was ace king, and the flop was like king 8-4. And he folded top pair with either top or best kicker, and people were like, never would anyone fold on a set, what do they call it? Not a C bet, but no one would ever fold on a bet like that, given that hand, unless they knew that they were already beaten. There was no chance playing it. So, I mean, that's it. So paragraph 58, you say, in short, Mr. Postle's poker winnings, considered in the prism of both metrics and hand-for-hand decision-making on Stone's Live Poker, have been not merely outliers, but in fact exponential outliers, representing a quality of play multiple degrees higher than that achieved by the best poker players in the world. Personally, I don't like the way this is drafted, because this is like weak argumentation as opposed to fact-based allegations. But they're trying to tell a story, and they're hoping that whoever reads this, my personal belief, they're hoping this never gets to trial and that the casino settles after they get their insurance company involved. But they're trying to tell a story now.
Yeah.
Now let me see what my next paragraph.
Well, James McCormick said it was Queen Jack versus Queen 10, and the flop was Jack 9-8. So one guy
flops top pair, the other one flops a straight, and he knows to fold his top pair.
Yeah.
It happens once. I mean, that's the thing, is like, it was the frequency with which it happens. And when you get so many people who get so interested in this, putting all of it together, it's like, what was it on the Muppets where he says, Mr. Jones, this is your life. You get people who basically compiled a year plus worth of hands to really bring out how impossible it was. It was just impossible. It is. That's the bottom line. It's impossible. Now, is it like that scene in Magnolia, the intro scene where it's just impossible, but it actually happened, or is it just impossible and it happened, but because of cheating? This is what they're going to have to allege. All of these things, incidentally, these are all allegations. These are not facts. They have to be proven. They have to be fleshed out. They have to be supported and justified. But this is the story Veronica Brill and others are trying to tell. Here we go. Paragraph 61 says Mr. Postle was able to achieve these results by engaging in a pattern and practice of using one or more wire communication mechanisms to defraud his opponents by gaining knowledge of their hole cards during the play programs.
But how do they know that though? They haven't sufficiently alleged how they know that. That's a baseless allegation right now.
And that's, now that I'm reading this, despite what I believe, I read that as not only a baseless allegation, but it's a fabricated allegation. It's made up on it's a conclusion from their presumption that he was cheating. They say he was cheating. How could he have done it? It had to have been a wire communication mechanism. Like, I mean, in theory, there could have been someone under the table tapping his toe, and it wouldn't have been a wireless communication. He still would have been cheating. So they're making these very, very broad conclusions, or so I say specific conclusions based on these allegations that they think he was cheating, and this was the only way that he could have done it. But that's an allegation that they have to prove.
Yeah.
64, 66, 68. And Nate, tell me if you see anything in between that I've missed. This is the one that I found very telling. And everyone should pay attention to this. Whether you think he's guilty or not, this allegation is a flag. For the avoidance of doubt, the plaintiffs make their allegation of Mr. Postle systematically, habitually, and regularly cheating at Stone's live poker games based not on a hunch or suspicion correlative to any one specific cheating device, but rather based on statistical analysis of his results and analytical review of the manner in which he played. And that, they're basically saying we have no evidence, but we are making our conclusions, and we're basing our claim on the fact that his statistics were so impossible. There has to be another explanation other than his skill. Yes. I mean, the one thing for anybody who plays poker is if this guy is as skilled as he is, why only play 2-5 or 1-3 at Stones, and why not, be at big high stakes games where you can make even more money? But that's all argumentation and not evidence.
It's trying to tell a story through statistics, which I understand, but it's just not. It's okay. You're showing that the statistics are crazy, but now you're just throwing out. Well, I think it was radio communications or whatever, which is just which is like, okay, but you haven't given me anything. Again, that's just a guess. It's just a hunch.
Yeah. Well, now, and we'll get into it afterwards. But some of the evidence that has since come out, I think, since this was filed. Apparently, someone in the comment section can correct me. Apparently, they caught a screenshot of a blue screen on his phone, which a lot of people are saying was some sort of interface, and not app. What's the word I'm looking for? Whatever. So, some sort of system that would give them the information, because nobody looks at a blue screen on their cell phone. And other people are just going to point at his ridiculously bizarre behavior at the table, carrying his between his legs. I think Joe Ingram called it the CTO, the crush theory optimale, which is hilarious. But yeah, no, they're saying it has to be wireless because we believe he was cheating, because there's no other way he would have won this much.
And it's funny because I've watched like maybe 3 videos on people say, I know how he cheated, and everybody has like a different theory. And I think this is the problem when you get to this lawsuit. What is what is it? If you're coming to court and you're filing this, you have to have something more than we believe it's this way because we have no evidence, No,
that's the thing. And I think that they filed the lawsuit on the best of the evidence they have, hoping to get to the discovery process where they can then depose someone from Stones, get the results of the Stones internal investigation, get their eye in the sky footage, get their data from the stream, and then they're going to find what they get. My concern is just that as drafted, they might not even get there because someone might come in with a motion to dismiss for fail. I mean, the terms better than I do, but
state a claim,
and dismiss it before they even get to deposition to even find it. Like, this sort of seems like, please, begging us, let us get to a deposition so we can look for more information.
But the question is going to be, even if all of this is true that you've alleged, can you win your cause of action? I don't know if they can, based on what we've just read right now.
Yeah, no, that's it. And now 66, Let me just bring this down. There exists 2 instance-specific evidence of Mr. Postle being aware of other players' precise hitting cards. On one occasion, he visited the commentator after a Stone Live poker game to discuss his play and indicated he was aware that a specific hand had only displayed 2 of our cards to the viewing public, whereas 4 cards should have been displayed because they were playing Pot Limit Omaha, even though he would have not had the opportunity to view the broadcast and thus become aware of this technical malfunction prior to making that comment, unless he had illicitly. This is getting confusing, and I don't.
No, I actually saw this. He was playing I forgot they're playing Omaha, and you get 4 cards. But during the game, for some reason, the people in the back, the commentators, could only see 2 of the 4 cards. So they were like, "Oh, something's wrong with the system. We can only see 2 of the 4 cards." And in that game, one guy had like an ace. He had an ace king showing. It was like 2 clubs showing, and the other and he had a jack and a 10. So he eventually got a full house, but he didn't know whether the other guy had hit his hand. So he was scared to say like, "Oh my God," it was that one time where he's like, he didn't really know what the other guy had, but he called and he happened to win. And then when he went to the back, he had said, "Yeah, I could only, only 2 cards, only 2 cards." And that's what they're talking about. How did he know that you could own that the people in the broadcast booth could only see 2 of the 4 cards? He shouldn't have known that.
Yeah, and incidentally, so there might, and that's the thing, there might be another explanation for this. I brought up the comment, like someone might have said we only saw 2 cards and they knew that in real time. I made a similar comment on, I think it was a Dave Polk live stream where I said, as far as I was concerned, the smoking gun was when he knew that the other player, when he told the other player to scan his cards over the RFID reader. And I said he would have never known that they weren't scanned unless he knew. And I was like, "Oh, well, I'm convinced." Except someone told me that apparently the dealer told the player, but we didn't hear it because of the audio. So there might be some explanation as to why he knew that only 2 of the 4 cards had been read. But that would be pretty decent evidence. If there's no other reasonable explanation, that would be pretty good in terms of definitive explanation. The only question is, that someone might say, "Oh, yeah, the dealer knew and somebody knew in real time and was trying to get him to scan his cards properly, and that's how he knew, and he complained about it after the hand."
That's what I would argue.
Yeah, no, that's it. And especially, now that you get to see the lawsuit, you get to prepare your defenses. And it says here, while there are only a handful of live poker sessions at Stones, Mr. Postle did not make money. Oh, sorry. While there are a handful of Stones live poker sessions in which Mr. Postle did not make money and in which he played in a suboptimal manner, the plaintiffs have information and a belief that such sessions correlate to the absence of Mr. Postle's suspected chief confederate, John Doe, and plaintiffs further alleged Mr. Postle's participation in the blah, blah, blah. So they're basically saying where he didn't win, we've correlated it to somebody else not being present, and that's why we think that this specific person, when he wasn't there, even when Postle was playing, he wasn't winning. That's why we think they're working together. Okay.
Well, again, now we got a mystery person who we think is working with. It really now is really getting tenuous at best. I think their strongest piece of evidence is the statistical analysis, which I think they've poorly given us because they haven't given us real context to it. What does 94% win rate mean? What does that mean for any other poker player? And they haven't really given us that context. And here they've automatically added an extra person who they believe maybe, but then really haven't given us any facts to help lead us to the conclusion that yes, he had somebody helping him. Because again, he could have had an RFD reader or RFID reader on his phone. That's reading a card. So there could be a multitude of different ways that he could have been doing this.
Well, and you mentioned it and you bring it up. And now that I think about it, we haven't seen one exhibit filed in this motion, right? Like nothing to support the claim.
No.
You say like, if I were drafting it, I would have included graphs of the statistical anomalies and how much of an outlier it is for visual, like the same graphs that we saw in Joe Ingram's live streams. That graph, the blue clump of dots with,
Yeah.
I would have been, as appears more fully from a graph of the statistical anomaly communicated here with as whatever exhibit. I would have included the breakdown of his success rate, but maybe they didn't have it when they filed the suit. But when you see the win streak, black and white on paper, and his 2 reds, and then I don't know, what was it, 36 winning sessions, then it helps you visualize what they're trying to tell. But no exhibits seems maybe not ideal in terms of drafting, in terms of compelling drafting. Where would I want to go now? Paragraph 77, we'll skip this. Oh, so then they talk about how they complained people were complaining about the cheating, and Stones basically said, no, there's no cheating going on. Curatus told multiple persons that there was no cheating. They did an internal investigation into themselves, and they concluded they had done nothing wrong.
Now this is where they're trying to get the casino on board with the RICO piece. That, hold on, they were actually working together, and this whole we investigated but really didn't investigate. They're trying to say, okay, that was part of this whole scheme to defraud us, because the casino was supposed to protect us, but really what they were doing is working with this guy to defraud us. That's interesting,
and it's an interesting way to phrase it with the RICO, that they're trying to paint this as collusion or conspiring as part of what do they call it? An enterprise.
Yes, criminal enterprise.
Criminal enterprise. Where if I'm looking at this, I can understand going after the RICO for whatever the reason, but I would probably more argue that this is the negligence of the casino, to say that they didn't do any meaningful investigation, and they could have stopped it earlier had they. But they could have stopped. They could have stopped earlier what we believe was occurring based on, what we don't believe was probable in terms of results. We don't know that anything was occurring that there was to stop. So, okay, I mean, that's one step. It's one step to go from arguing the negligence of the casino, but now they're trying to argue the collusion of the casino as an enterprise with Postle for whatever the reason. It's going to be an uphill battle. Yeah. Paragraph 77. It is not clear how a full investigation could have been carried out by Stones prior to September 29, 2019. None of the plaintiffs herein, all of persons who played at the Stones, were ever approached or interviewed in furtherance of such an investigation. And upon information and belief, neither was Mr. Postle. As a Canadian, Nate, upon information and belief, is that just like, that's a convoluted way of saying
hearsay?
Okay.
that's that. Upon information, belief is hearsay. That's what it's saying.
I hate legalese. It's like it's as unreadable as poetry with none of the beauty. So, and I'm skipping here now. Just go to paragraph 82. However, even in announcing an independent investigation team, this is after they decided to reinvestigate after the poker community got involved. Stones continued its pattern and practice of misleading the public, as the individual Stones publicly designated as heading such team, Michael Littman, is in fact the attorney who had previously represented Stones, who has also served as personal counsel to one or more of Stones' principals, and who, as recently as October 2019, Stones referred to as outside counsel. In short, while very much a respected and able attorney, Mr. Littman is most certainly not independent of Stones. That's an argument. I might argue that you get your own counsel to investigate. They're the ones who are going to sensitize you to your risks more than anybody else. But
and you get attorney-client privilege too, so that also helps too.
That's a good point. That's actually, now that you mentioned it, I hadn't thought about that. If there is attorney-client privilege and they ask for the results of the investigation, he would, in theory, be able to invoke solicitor-client privilege to refuse to give to hand over the results of the investigation or any correspondence relating to it.
If it's damaging, yeah, you get to choose.
That's good, Nate. Good reflexes. Very good strategery on behalf of the casino. But, hey, 286. General allegations, damages. Okay, so they talk about how he profited more than $250,000. Each plaintiff played with Postle. Yeah, here, paragraph 86. And if we want to talk about arguing from a conclusion, Mr. Postle would not have won such money if he was not cheating.
That is a hell of a conclusion right there.
Hell of a conclusion. I mean, I can understand it just given the duration of the win streak, but whatever. I guess you could flip a coin and it could land on heads every day for a year. It's not inconceivable. Okay, Nate, am I skipping anything that you wanted to touch on?
No. I think you've hit it all. It's just, I just want to make the point too before we get to the actual allegations or to the next section, is that I have heard nothing here that ties Matt Poste to the casino in any criminal enterprise. I hear they were negligent. I hear he is cheating, but there's nothing I hear that ties him to the criminal enterprise. So right now I'm just thinking about the civil RICO statute that they're trying to affect. It's just not here. I don't see it. I don't know. Maybe do you see it? But
Well, no, I mean, I'm not familiar with RICO. I think we have something of a similar type of RICO. I think we have something similar in Canada. But knowing what RICO is, and from my limited understanding, that you're trying to prove the criminal enterprise so that you can go after those giving the orders for the acts carried out,
Yeah, well, the first
the underlings.
Listen to this. Here's the first element. The defendant person was employed or associated with the enterprise and either operated or managed through a pattern of racketeering activity. So I'm trying to see, it doesn't seem like they're really associated or employed by any way. He wasn't like their agent or anything like that. He was another player. If he was cheating, then you really don't have this. You know what I mean? Because he could have been cheating on his own.
No, they're hoping that if they get to discovery, they're going to get emails or correspondence between Postle and Stones discussing how they're going to do this. And that's even assuming that Stones as an enterprise is involved in it. And it wasn't just, I don't want to pick on Curatus as an example, but that it wasn't just Postle and an insider, and that the Stones may have tried to cover it up after the fact, not as part of a criminal enterprise, but just to cover their ass and, try to minimize the damages.
Here's some more outside information. I got two people in the chat. Night Seek says Postle was a producer for Stones, a attorney called Dream Seek back in 2017. They should have alleged this in the complaint because you can't go back. And then James McCormick said right below that, look, if he said something about him being an employee, so I didn't.
Let's see, this one here. No, that's
no. There you go. Postle helps set up the stream. There's someone right above that.
Well, if that's true, now you have something. That probably should have been helped. That's sort of like why the employees of gaming enterprises can't participate in the giveaways type things. Okay, well, it's fascinating. And so if we go to the general allegations of the live stream security, this is stuff we sort of already know, but operating a live stream does not have to be a security risk. Numerous poker rooms have different RFID technology. By way of anecdote, the Los Angeles, I'm at paragraph 91, just if anybody's looking here. Okay, they're talking about how other casinos do it properly, and who cares about that? 92. Stones, however, utilized an appreciably more lackadaisical approach to security with its Stones that's the second typo in there. Stones live poker stream, allowing the room in which concealed information is reviewed in real time to be readily accessible by numerous people, by not constructing a proper security perimeter around the production room, by allowing the use of cellular phones in the production room during Stones live streams and otherwise. You see, this is the thing. If they know this information in paragraph 92 to be a fact, that is what I would have been fleshing out in this lawsuit. Names and witnesses of the people who they know were going in and out of the production room, or evidence to that effect, not a recapitulative paragraph 90 paragraphs into the lawsuit. And it's very easy, those who don't draft can correct, but this is the crux of the information. This is almost more important than statistical anomalies.
Yeah, I agree. If they can show that, because they're showing that this casino breached the standard of care. There's a certain standard that the industry, just like a doctor, if you have this, the doctor's supposed to do X, and if the doctor doesn't do that, then they're negligent. That seems like what they're trying to allude to here. This casino was negligent because it just didn't follow this particular standard of care.
And if I'm the defendant, if I'm any one of the defendants, and I get this, I don't know what you have as you have motions, or they called requests for particulars.
A bill of particulars, yes.
I would sit there and say, paragraph 92, I want to know everything about what you're talking about here. Who went into the room? When? On what occasions? What did the room look like? How did they get in? I would like to know all the details of this, but then knowing full well that there's sort of be careful what you wish for, because if I ask the questions, they might provide the information. But I have a sneaking suspicion they don't have any supporting information for this. These are just general allegations, whereas they would need to, or I would be, turning over every stone that I could find to get details to substantiate that paragraph.
Yeah. But again, maybe they're hoping to just get through discovery, because that seems like where they're putting a lot of weight on discovery here.
Yeah, that's if I were going to bet on if a motion to dismiss is going to be brought, I made my prediction on the Nicholas Salmon. I would bet that if a motion to dismiss were brought on this one, I could much more reasonably see it being granted than I could in Nicholas Salmon, Washington Post. But
agreed.
I still am angry when I think about that. Not knowing where that lawsuit is right now, I'm still angry. So someone says there is video proof of this Nightseek. It's interesting. If there's video proof of it, get the video. Yeah. File the video with the lawsuit. File it.
But a couple of people have been saying this in this chat about, why didn't they know this? The thing is that when you have a claim, when you have some claim and it's not in the claim, it's like it doesn't exist. So this outside information that some people are saying, hey, I know this, and that's great. But if it's not here in the complaint, this is what the judge is going to use to see if this case is going to go on. So all this information about him doing the streams, that should be in here. And if it's not in here, then it's like it doesn't exist unless they amend the complaint. You know what I mean?
That's an interesting thing that everyone should appreciate. These are all, we say that allegations are not facts. They're just allegations in a lawsuit. If you don't allege something in a lawsuit, you don't get to make that evidence in front of a judge, which is why if you have a document or you have a video or you have a picture or you have an important fact and it's not alleged in the proceedings, come trial time or come whenever, you can be barred from actually raising it or filing it because it ought to have been filed in the complaint so that it could be discovered by the other party. So it's interesting, Nightseek. I mean, the information that Nightseek is bringing up, it's interesting. It would also, if to the extent that it's true, it's also interesting that it's not in the lawsuit itself. Yeah. Here we get the RICO, Racketeer Influenced and Corrupt Organizations Act. It should actually be RICOA. And if they should have gotten an L in there, so they could have done RICOLA. But oh my goodness, the Racketeer Influence and Corruption Organization Law Act. Then you got your RICOLA. Everyone knows what RICOLA is?
No one probably knows what RICOLA is.
And they had the commercial and it goes RICOLA. Okay. Maybe I'm very old. Okay, so paragraph 95. Mr. Postle, John Doe's 1 through 10, Jane Doe's. This, Nate, I think you'll tell me from a legal perspective is done on purpose and important. Quote, devised a scheme or artifice to defraud or for obtaining money by means of false or fraudulent pretense and representations in furtherance of which they did, quote, transmit or cause to be transmitted by means of wire communication in interstate or foreign commerce, signals, pictures, or sounds for the purpose of executing such scheme or artifice in contravention of section 1343, Title 18 RICO. You want to explain why they have to say it that way?
All right, because, well, they're trying to establish the elements necessary to keep this cause of action going. And here's the elements for the RICO claim. First, you have to have a defendant or a person that was employed or associated with the enterprise. That person must have operated, managed through a pattern of racketeering activity. And racketeering activity are things like, kidnapping, murder, any type of, we're looking at criminal activity, loan sharking, this type of fraud that they'll be alleging soon. That criminal activity is the racketeering activity that you would also need. And you'd also need to establish now the civil liability that they're going for. The plaintiff must also establish an injury to a business or property by reason of a pattern of racketeering activity. So in other words, they're saying because of this fraud that they were doing, that harmed them, that took their property, their money. So here they're trying to allege that this guy and these John Does who work for the company, came together and more or less defrauded them, and that's the criminal enterprise, and that gives them this RICO. But I don't see it though. I don't see the connection. Even though some people are saying in the live stream, there was the live stream, he did this, he did that. None of that's alleged here. It just kind of says he was cheating, and we think that maybe somebody who worked there may be involved. They were negligent in some cases, but it really doesn't say that he was really associated or employed by them in this way where he was managing this racketeering activity. I just don't see it. Maybe you do.
No, I don't see it at all. But now I understand it, at least, because I was trying to figure out why they were drafting it in this specific terms. And basically, to get the casino on the hook under RICO, they have to allege that John Doe, Jane Doe, and Mike Postle. I'm looking at my mic like it's the camera. They basically have to allege that all of the other defendants were working in an enterprise with the casino for the purposes of this fraud.
Yes.
As opposed to just alleging the negligence of the casino to hold them liable on the basis of negligence for the casino, vicarious liability for the employee of the casino. They want RICO in here for some reason.
Yeah.
Isn't 95, sorry, not Old Grumpy one. You're not the only one who's old and grumpy here, Old Grumpy. Isn't 95 trying to, sorry, I got to get that out of there. Let me see something here. include the video evidence, etc. If they're trying to include video evidence, Nate, you'll correct me if I'm wrong. They need to file the video with the lawsuit, right? It's not something they can bring up later as evidence.
Well, but you can. It just has to be authenticated. They don't have to file it at this particular stage. You just file the complaint.
Do they have to disclose its existence or communicate it, so to speak?
Yeah, and that's what they're doing. Yes, they communicate the existence, but at this point in time, you're just filing your allegations. You can give it to them, but sometimes you want to hold that back because you don't want to give the defense the bite at the apple to see everything you have. You can just say, "I have this stuff," and that's what I'm thinking they're doing here. Just saying, "Hey, I have this stuff," because they're trying to survive this motion to dismiss. If this charge, and think about this, if this RICO cause of action is dismissed, then they lose federal court. They then have to get their case will be dismissed in federal court automatically. So this charge to them is very, very important. They lose this, it's dismissed in federal court, and then they'll have to go back to state court. The same thing that happened with the PragerU case. So for them, this is very important. And here, the thing is that I'll say if you claim all of the if we assume all of this is true, we're saying these are not allegations anymore, these are facts. I think the fact is, it doesn't seem like they've pleaded enough where they can win on this particular cause of action, this RICO cause of action. I just don't see the connection. They've not alleged that connection between the player and the casino sufficient enough where you can have where they were working in a criminal enterprise.
Okay, and if we go to paragraph 97, actually, and it says, based on a review of video footage of several Stones, they have it again. Live poker games. Man, they got to go through control search for Stones like poker and Stones live poker. So they're saying basically on a review of video footage. If I'm the defendants, Nate, I don't know what the American procedure is. Do I get to say what video footage are you talking about? Show me the footage. Like, do I get to ask for that as not a request for particulars, but disclosure of evidence?
Well, you get this in discovery, right? And plus, don't they have the video footage? Because they've reviewed it already. They're saying we have the video footage, right?
Well, I'm taking for granted the video footage they're referring to here is the video footage that's all over the internet already. Yeah. But if it's not, I'd like to know as the defendants to know what they're talking about, and I'd like to see it before. I mean, I'd like to see it in tandem or in conjunction with their lawsuit.
Well, but I think this you'll get this with the discovery phase. We have loss, we have this to prove our cause of action. Again, here's the complaint. If all these things are true, if you have, because again, that's what we're saying. If all these things are true, if you have the video, we're saying you have all this information. Can you survive a motion to dismiss? And so this is what they're giving us. We have all this stuff, and it'll provide it after the discovery phase. During trial, I'll hand it over.
And here in paragraph 98, the mechanisms through which such information was fed to Mr. Postle and Jane's Doe is known only to them as of the filing of this complaint, and will be learned through discovery herein. That is like
a fishing expedition.
Yeah, that's like begging me, please let me just get to discovery to see if we can find and substantiate these allegations. Okay, so then we talk about the dates on which the stuff happened. Okay, because I guess they might have learned from the fraud in the Smollett case, where I think Smollett's attorneys were saying you didn't allege the specific date of the fraud, with whom it occurred, and the circumstances, and in the response to their motion to dismiss in that case, if anyone hasn't read it, they said we sure did. It was on X, Y, and Z dates, and it involved Mr. Orange, Mr. Pink, and Mr. Black. So I mean, I guess that's what they're trying to do here, is just be specific on the dates so they don't get called out by not providing enough information.
I think so, and again, it gives the court, because it seems like if you're putting all these dates and you're saying you have video evidence for it, they're saying these are the dates we have the video evidence for. Here it is. Boom, 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 boom.
I guarantee you one thing: Joe Ingram is going to get called as an expert in this if this ever gets to trial, to go through the footage that he analyzed. And I think I had one more paragraph that I had flagged here. Let me just see this. 118. If we're skipping here, we got a bunch of we got the fraud charges. I guess do you want to go through the actual criminal charges, or not criminal? Sorry, the actual civil fraud charges.
Okay, yeah. Well, first, the first one is the elements of fraud. So first, you have to have for deceit, you have to have and this again, since we're talking about California, this is under California law. We're talking about and again, this is not legal advice, but so we're talking about misrepresentation, false misrepresentation, concealment, or non-disclosure. So if he had this ability to see the cards and everybody thinks that this is a fair game, then you'd have this misrepresentation that it's a fair game, or they didn't disclose that he had this ability to see their hold cards. So that would be the first element. I think you have that. You would need the knowledge of falsity. So they would have to know that this was a false misrepresentation. They would have to have intent to defraud. So, or intent or induce you to rely on my representation that this is a fair game. So I'm saying it's fair. You can trust me, and then I induce you to play because you relied on my disclosure or my non-disclosure that everything was fair. Your reliance had to be justified. So you can't just say, well, I believed them. It has to be justified reliance, and you have to have some damage that results. So here, I think for the fraud, you may have something here. I think if the claim here is that by not disclosing the fact that he had this ability, even if they knew it, because they may not even know that he had this ability, then yes, you would have fraud. But again, I don't see how the casino. We could be in a situation where the casino themselves had just a security lapse, so they wouldn't be on the hook for fraud. And now they were just saying the player is on the hook for fraud, but I don't see how you get him on the hook for fraud either, because you're saying he's cheating, you're saying that the statistics shows that he's cheating, but you don't really have, it's just not there. No, I don't know.
So I forget. I would say I'm trying to read where the comment was here. As much as I think cheating happened, the more I read this filing, the weaker and weaker it sounds. And the more I read it, the more I agree. I mean, it's like it is all drafted on the assumption, on the presupposition that he cheated, and now it's fraud because he cheated, but they haven't proven that he cheated yet. But for the statistics, but it's interesting. The fraud I can understand. The fraud I can understand, or negligent misrepresentations against the casino, I can totally understand if the cheating occurred. But man, they have to get to step one before they can get to damages.
Yeah, again, like even for the fraud, it's just like everything has to be assumed. You have to assume that he was cheating, because then that would give you the non-disclosure. You'd have to show that they knew that he was cheating. You'd have to show that they intended to defraud. Like all this, I just don't see here in this lawsuit. I just don't see it.
Here we got paragraph 118, which is under the negligent misrepresentation section. Negligent misrepresentations, which presupposes the cheating. Stones also made representations implicitly by conducting Stone's live poker games in a licensed casino wherein there exists an implicit representation players are protected from cheating of other players through utilization of adequate and sufficient security measures and protocols. Yeah, they warrant that, but there hasn't been proof that there was actual cheating yet, other than his inexplicable success rate and bizarre behavior at the table.
Well, here I think you may have something, because let's say if we take the statistics and say, okay, the statistics are good, he was cheating based on the statistical analysis, because I think you can use statistics to prove your cause of action. For instance, for those for let's say if someone says like talcum powder causes cancer, and you find out that there's a high statistical anomaly that people who use this particular product get cancer. So it does happen all the time, and I think here you may be able to have that argument, but I think when you're talking about negligence, for instance, this I think the casino may have a problem with, but again, you would have to say they were cheating. You owed a duty to the plaintiff, and you breached that duty. And I think the duty here was you have a game, you're using these particular chips, and if the system is flawed in terms of somebody can breach that, then you breached that duty, and now you've been negligent. What's the industry standard that you should be using to protect the players? That's what they were saying earlier. They were saying, well, the industry standard, here's the World Poker Tour, here's here's all these other places. They've never had a problem because they use the industry standard stuff. Here we have a problem because they failed to do what everyone else does.
Nate, are you licensed to practice in California?
No.
Well, you made that's the most compelling argument, which I might have alleged or found a way to incorporate into the proceeding, which is all of these, I don't want to say malpractice, but product liability cases where you talk about Roundup causing cancer. And it is ultimately, I think there is probably a direct scientific correlation in some cases, but in other cases, it's just people living in a certain area suffering from certain ailments, and we draw presumptions of fact, or we draw presumptions of fact from a set of circumstances where I could see them coming to that conclusion if the argument is made properly. It would be the same thing as correlating disease to exposure, which can never be definitively proven. It is purely statistical. I can see that's a strong argument, which they might have been better off fleshing out in here.
But there you would need a control group. Like the way you do that is you have the comparison. Here's a control group. In the general population, this doesn't happen. But now if you add this to it, if you add, talcum powder to it, now you have this increased risk, all of a sudden X amount of people are getting cancer. So, but again, I don't see they seem like they tried to do that here, but I don't think they did it well enough to survive.
I'm nervous to ask if Nightseek is someone who works at the it seems like he has a lot of information. Okay, so
you should have helped them. You should have helped them write this complaint so we can get it all in the complaint.
No joke. The lawyers should crowdsource not just for the video data, but for the information. Like go to the community and get people's arguments and get everything that is out there that one lawyer working 24 hours a day would not be able to get. Okay, I think we're good with this. I'm gonna take it out, and what do we want to do? Negligence against so we got the claims of negligence against the various parties, and they sort of reiterate the paragraphs set forth, and then they go into specific detail as to why Stones should be liable, why Curatus should be liable. I think we can minimize this now. What does everyone think? We've seen enough of this lawsuit? Okay.
Yeah, it just what it comes down to. Have you seen enough to believe that they were working together to defraud the other players? Does this lawsuit allege that? And I'm saying I don't know if it does.
I actually think I liked it better this way. That looks kind of nice.
This is pretty good.
Yeah, that's the thing. So you got your RICO claim, which is they're working together as an enterprise. Postle, Curatus, and Stones. Stones was handing down the orders, the big boss, and Postle and Curatus are carrying out the hits, so to speak. That's RICO. Then you've got your fraud. Oh, sorry, go ahead.
No. James was asking they. What I'm speaking by they is the player who's alleged for cheating and the casino. Remember they're talking about this enterprise. Everybody is together doing this for this common goal. That common goal is to defraud the other players, the $250,000. So I'm trying to figure out how do we get that from reading this complaint? This complaint, I just don't see that working model.
And it's the funny thing is the first question I was asking myself a while last week, or when I first started looking into this, is why would the casino why would they even willingly be involved in this? And a number of explanations are that it was an up and coming casino. They wanted to build up this phenom Postle to get other big poker players to come and join the casino for brand recognition, et cetera, et cetera. I may or may not be convinced about that in terms of what they were risking the casino. It's not like this is something you'd want to risk as a casino for something so, I would say superficial. So my gut logical instinct would be the casino was never involved in it, but they might have been new to this type of technology and not taken the proper means to protect against cheating if the cheating did go on. Would I have any problem believing that any employee or someone in the control room would be in on it and say, Postle, dude, there's a weakness in their system. Like this is like Ocean's 11, 12, or 17, whatever they're at. There's a weakness. Let's exploit it. And I have no problem believing that either. I would have no problem believing that someone might have known Postle's precarious personal situation and knew that he might have been a good target to exploit, and then say, come, this is what we can do, and we'll give you a cut, and just all you have to do is place the bets. Let's see here. But so, I mean, I don't believe the casino would do this willingly, which if I'm sitting there as a jury, it would take a lot of convincing that there's a RICO type enterprise going on. The negligence I could buy.
The negligence I think you have, because I think here's the standard of care. What do everybody else do? They do this. And I think the negligence is your knockdown argument. I think you have that. But again, even with that against the casino, you'd have to show that, what they're doing is somehow different than what everyone else is doing, different than the industry standard. If you could show that, then I think you might be able to get it. And then you also have to show that was the direct cause of your harm.
That's why I brought up Sonny Korax's comment here, because using your phones at the table is suspicious. No question. I never in a million years would I suspect that would be tolerated. but suspicious versus the cause of the cheating are two different things. Yeah, let's. I mean, it's yes. Nightseek says Postle ran the company that produced this show. That ties to conspiracy. If he did, and that's not alleged in the
it's not alleged in the complaint. Like you're giving us. They call this facts, not in evidence. You know, you're giving us a fact that is not. If that was alleged in the complaint, then I'm like, okay, now we got a problem. Now we have something, Rico. They're going to have to amend the complaint to get you, Nightseek, to come in and say, hey, tell us all this information so we can get a good complaint. Because right now, the information you tell us is earth-shattering. But it's not in the complaint.
And they would have known that he ran. I mean, they would know that would be discoverable. They should know that from the complaint. But Nightseek, pull up that lawsuit and email the lawyer if that's. I mean, that's. I'm not sure I would do that, but that's if that is true, that ought to have been alleged in the proceedings. That's a material fact that would have material impact.
That's game changing. That's game changing. That's something that gives you your Rico. That gives you, hey, he's working directly. He was one of the guys. And then what the hell is he playing on the table for if he does have this relationship? You know, or people in, because I know when I used to go to Atlantic City. You know, the first thing that the dealers say, we can't play at the casino we work at. No one can play at the casino we work at. It's the appearance of impropriety. But this guy, he's running live streams, and what did Seeker say? He's all hooked up with the management team. That's a problem.
That would be bad. Is Sunglasses Guy a lawyer? Yes, Nate is a lawyer out of New York. Wears sunglasses for reasons, Nate. If you want to tell them, it's
yeah, it's just I'm blind in one of my eyes, and since I have to have the light on, it bothers me. So. That's the reason.
And this week we went out. I assume that everyone watching this stream would have watched the first 3 streams, which were an hour and a half long. But no, that wasn't to make anybody feel bad. It's just to explain why Nate's wearing sunglasses. So let's hear. What if anyone's got any questions that we missed? Put them in here. Let's just see what we got here. I think public opinion is enough to reasonably punish him. He's done.
Oh yeah, for sure.
He's even if he weren't cheating. I suspect every casino in the world would want to ban him just just to keep him out.
He walks in there, I'm walking out. This is the guy that knows the secret stuff. But I think the problem here is that I think this lawsuit needs to be flushed out a little bit more, because if the facts that we're hearing from the live chat are true from these people, from the people in the live chat, this lawsuit is horribly underpleaded. Then it just doesn't have enough.
100%. If some of the stuff that some of these people, some of the people in the chat are bringing up are true, to the extent that they're not in the lawsuit, they're missing maybe even the crux of the bulk of what they need. Epic says it's not about likelihoods; it's about how his hands were played over and over again. No one would make those decisions unless he knew his opponent's cards. Poker players might agree. The question is, how do you prove it? I mean, that's fine. That's a conclusion. That's an opinion. You have to prove that. But
it's not what you know. It's what you can prove.
Oh, say that again.
No, I said it's not what you know, but it's what you can prove.
I mean, 100%. But if he was related or had anything to do with the production company that was doing the live stream, I hope Joe Ingram is watching this right now and will put this in one of his live streams or one of his videos, because that is I don't want to say if someone knew that and didn't allege it, that would be a very big problem to me as counsel.
Yeah, that's crazy. I don't know why you wouldn't put that in here. That's your smoking gun. That's it.
Absolutely. I mean, and then you have corporate records, and then you get to subpoena the documents of whoever put on the live stream. And yeah,
was he getting paid from the casino? It seems like people just were upset and just like, we got to put this lawsuit out. But you have a lot of crazy stuff going on if he's associated in that way. And it's funny because I saw him sometimes going back there and talking to the commentators and things of that nature. So it seems like he had some relationship with the casino, but I don't know if it was enough to where they were in a criminal enterprise. I think the casino was negligent. I really think negligence is the best thing here, but the other stuff is a little tenuous.
They would be negligent if there was proof of cheating, which there is yet to be. Nate, what's the statute of limitations? Like, how long do they have to file the suit under these circumstances for a civil suit?
Well, I'm not sure in California. I know in New York it's like 5 years. So if you have a negligence claim, it's like 5 years. But here, I'm not sure. And so it's not like when did all these start happening? In 2017? That's when
stuff hit the fan in September of this year. It started.
Well, I don't know how it is in California. I know here it's when the first incident occurred where you could have started your cause of action. So if that happened to be 2 years ago, that's when your clock started. So if 2 years ago the situation arose where you could sue at that particular point in time, then that's when you're supposed to sue.
Here, Jeremy Anthony. Jeremy, how you doing? Boggles my mind if Postle was involved in a long con. Why have a win ratio of 94%? Alarms, of course, are going to go off. Any smart con would go, not to get to ridiculous with the winnings. Well, so I'm not repeating this information because I know it myself. I just know I saw it on, it was Dave, I think it was a Dave Polk live stream interviewing, I'm going to forget who it was now, but there was discussion that he might have been like desperate for funds. That was one thing. Apparently some people thought he might have owed other people money. There's a number of reasons why urgency might have been high on the order. The other thing is, you know, if it had been played smoother, maybe you could have gone with 94% rate, but over half as much time and nobody would have noticed. But there might have been other reasons that people were throwing out there as to why there was a certain level of desperation.
Well, also, I think who made a very good point about the it's not beyond a reasonable doubt, but it's a preponderance of the evidence, and a 94% hit rate. That's I think it's enough to say, well, yeah, it's statistically not insignificant, but I would need to know what is the normal, ratio, and then what does that mean in context? Like I would need to see that graph. Everybody's over here, and this guy's the only one over here 99.9% of the time, and no one else has made that.
Someone just said something here. Oh, this is an interesting thing, because I had the thought as well. What if he was approached by professional criminals? What if he was acting not out of free will, but rather out of compulsion? That's a defense.
Yeah.
And then
it's duress.
Yeah, it's acting under duress. You'd have the defense, and it would be, I don't know how far that defense would go over such an extended period of time, but I could easily imagine it. But then there would be an admission of guilt. There would be an admission that there was cheating going on. Thus far, obviously, Postle has gone under the radar. I did see some comments that he did lawyer up, and his lawyer is apparently very, very serious, whatever that means. But I don't know anything about that yet. There has been no, from what I understand, I don't think have there been what are they called, appearances in the States? Yeah,
they call appearance. Yeah, well, that's what it's called. Because again, some of these states have different words, but here they're called appearances. But one thing I want to just be clear about is that right now we have 94% statistical anomaly. Right, he's winning 94% of the time. Problem, yes. Cheating, possible, yes. All that. I think that you have something. But now, how do you get the casino involved? How do you get this? Because again, the casino could be a victim here too. We just don't know. And I don't think this complaint tells me enough where I can't say the casino's a victim. I can say the casino may have been negligent, but then even that, it would have to all depend on this, it's all dependent on this 94% win rate, which I think this guy's cheating. But again, it's tenuous at best.
So, and Bally asks, why aren't the police already involved? From what I understand, there are civil and criminal investigations ongoing. I don't know if there's any criminal suits yet, but I believe there's an investigation going on from what I've seen on other people's live streams. That's where I was thinking that this was going to go, is that the casino is going to say at some point, we admit that it occurred, but it was not, we had nothing to do with it. And it was in fact a rogue employee with access to, confidential information that did it. And in which case the casino, presumably, you'll tell me if this is right under US law, but will probably still be held liable for the acts of their employees vis-a-vis
vicarious liability.
Vicarious liability, but they'll turn against whoever it was and try to sue them for the damages. Insurance will still cover that, correct?
If you're vicarious liable, it should, because he would have been acting as an employee whenever they did this particular incident. So yeah, insurance should cover it, but I don't think insurance covers crimes though. So if you have a criminal act, your insurance may not go that far, but your insurance usually goes for civil damages. Yeah.
Well, I suspect. I mean, this will probably settle before it gets anywhere meaningful. If insurance gets involved and the casino doesn't necessarily want to take the chance of having this get to discovery, they can't get past the motion to dismiss.
No, because don't forget that discovery is going to also bring up, well, what did you do on your last when you said that he wasn't? Because don't forget they cleared him. So that's all coming out. I need to see what you guys did in your last investigation that said he was clear. And that's the first thing I would want to see. What is it? Because if that wasn't, if it's just we talked to one or two guys, they didn't talk to the players from when I read. They didn't do really anything. So if that first investigation was crap, then that's more proof of the negligence, and that could be more proof of some fraud. Now, why did you guys cover it up?
Okay, and I remember, before I forget the question, we talked about the dismissal. If the case gets dismissed with prejudice, which means they can't refile.
Yeah, that means the judge is going to look on this and say, that'll be if the judge looks at it as a basis or as a judgment on the merits, then in other words, another says if this is all you've got, then it's not sufficient enough to move forward. We'll dismiss it because this is all you have. And then if it's without prejudice, I think I said it wrong. If it's without prejudice, then you're saying, well, it may be just you just failed to state a claim. If you could find more evidence, then you can refile. So maybe this may be something where they can say, well, you find some more evidence and then you can refile. Because right now, I'm just saying for the negligence, I think you have something, but for all these other claims, it's just so really we only have this guy's winning 94% of the time. What does that mean?
All right, and before I forget, mandatory carry. Thank you very much. I'm going to bring that down now. It's interesting. They can amend in theory.
Yeah.
Let's say the lawyer's watching and he says, holy crap, goes to his clients and they say, yeah, I forgot to tell you that. The lawyer can amend.
Of course. First time by right. Yeah. Yeah.
Well, okay. Explain that because that's new to me.
Well, here you can amend after you file your complaint. You can amend the complaint the first time, so you can amend it one time, and that's well. I'll say this in the state that I practice in. So if I file a complaint and I misspell your name or I leave something out, and even if you may answer my old complaint, and then I'll say, oh, you know what? I forgot to say X, Y, and Z. I can then amend that complaint, and then you can file an answer to the new complaint. So sometimes it works that way, where you can amend your complaint. I think in the Salmon trial, they amended their complaint too to add some more cause of action. And you can do, and we usually say you can do it one time by right. So you have the right to amend your complaint because people like you were seeing in this complaint, there's so many mistakes. They may just want to amend it.
And one time by right, does that mean second time with permission?
Yes, you have to just get permission from the other side.
And if they say no, do you have to make a motion to court for permission?
Then a fight. That's the fight.
No. In Quebec, I don't think the rule even changed with the recent amendments. You can amend as often as you want without permission, and it's only if there's an opposition to the amendment that you then have to go to court and explain why the amendment is necessary. But if you oppose an amendment, you'd better have a damn good reason for opposing the amendment. Like one of the amendments might be that you would oppose is adding a defendant 3 days into trial. That would be like the type of amendment that one would oppose. But typically, just you can amend whenever, as much as you want. If you do it 5 times in a week, you might look like a total moron. But it's not an amendment. You don't need to ask for permission. You just like, oh, typo here, typo there. Let me add this. It might get annoying after a certain point, but
yeah. But I think after because after the first one, they'll you can amend it freely the first one, but after that, you have to kind of know what you're doing. And I think that's what this will probably go to. They're going to amend as they get more evidence. As they speak to some of the people in the chat who knows these all these great details.
Yeah, what was the name of the production company?
He worked for the casino? News to us. We just should have put that in the lawsuit.
No, it's amazing. I think the consensus is now, having walked through it, it may be nice, it may be well drafted and tell a story, but it's missing the substantive elements that are needed to really substantiate the claims that they're trying to make. Even the negligence is based on the cheating, and the cheating, other than the statistical anomalies, the statistical anomalies, the body language, the improbable play, because someone mentioned it, the improbable play has to be explained. That's not something that's like, it's not a broken window. That is, you say it's improbable, and then you got to get, I made my joke in my video, but you got to get experts in to say why that was improbable.
Yes. And
you might get diverging opinions. Like, yeah, you would play it that way if you're a bad player. And then you say, but he won when he played it, so he's not a bad player. He's a cheating player. It's conclusions from, it's a conclusion from a conclusion.
But let's even say this goes forward. And we were assuming that other investigation that they made was bad. But let's say they did do a good investigation that last time, and they found that, yeah, even though these seem to be odd, there was no evidence of cheating. We couldn't find anything with the RFD. Everyone's allowed to use their cell phone. So that could go either way. That could go either way to say, well, hey, we found this guy wasn't cheating. Here's the evidence. Here's why we clear them. So right now, no one knows. We're just assuming.
And James, it was so James says seriously, the suit didn't mention Curatus set up the Stones live gaming poker streams for Stones as an employee. No, I think what we're saying is at least it was Knight. What was his name? The comment before was that Postle was related or somehow involved with the entity that put all in, not Curatus, because and that's Curatus we would expect to be because he's an employee.
Yeah, right now we're trying to Matt. What's his name? I keep forgetting the guy's last name. Matt Poratus, right? No,
John Curatus.
No. I'm getting guys confused.
Mike Postle.
Mike Postle. Yeah, because right now we're trying to get Mike Postle at the casino and all these people wrapped up in a criminal enterprise somehow. So there has to be some connection. And this complaint, I don't see any connection. What I do see is I see Mike Postle playing. I'm seeing him having this 94% cheat rate. But now I'm trying to see how the casino facilitated that. Did they know he was cheating and allowed him to cheat? Right now, the only thing that we do have is they're saying the casino was negligent in the way they set their system up, that it was able to be hacked in this particular way. But they haven't showed how it was hacked. They just show kind of presumptions. We think it was hacked this way, but that they could be wrong.
Look at this. I mean, if this is true, there is a tweet where Postle and Curatus come together to test the RFID technology when they set it up. It's not like, and this is the thing that I was thinking the entire time, is maybe Veronica Brill, who's the chief plaintiff caller, maybe she has information that she doesn't want to allege in the proceedings. But like, this is not like in the movies where you get to, keep in your back pocket the most damning piece of information and spring it on trial. You have to disclose, you have to allege, because failing that, this might get dismissed on its face.
Yeah, what happens, and people do have to understand this, there's no such thing as trial by ambush. All your evidence is out there. Maybe they won't realize some line of questioning may lead to something, but there's no trial by ambush. You put everything you got out there, and you got to argue from that. If you're ambushing somebody, that actually here would be that's an ethical violation. There's no surprises.
Yeah, and we have the same thing in Quebec, and it's specifically, we don't have full disclosure in Quebec, unlike other provinces, but we have disclosure on request. So if someone asks for something, you can't hold it back, but you don't have to offer it like in other provinces or states where you have to communicate any information you think may be relevant, whether it's been asked for or not. So that's amazing. That's very interesting. I think they just took Postle being part of Curatus, setting up the stream as a given that they didn't include it. A dumb mistake. Well, hey, this is why the collective knowledge of the internet is an amazing thing, but we'll see where it goes. So now they filed this. Do we have the date? Let me just see if I can find the date that it was filed.
They filed this in California.
On the 8th of October. Jury by demand. Sorry, I'm going to bring this back up. So they filed on the 8th of October, which is 4 days ago.
4 days ago, yeah.
That's pretty new. So maybe they got this out in a haste just to get the ball rolling, and they're going to amend by right with new information. What is the next step typically procedurally, time-wise? What happens? I mean, general, if you don't know by California in general.
Well, I'm saying in general, you have to serve the other side with the complaint and all this other stuff, which I'm assuming they did since this is a corporation. So you have to serve all of them, right? Then after you serve the other side, then they get the answer. So we'll get to see the answer, whatever the answer may be. And that answer is usually going to follow with some type of motion to dismiss for probably failure to state a claim, which I would be easily throwing out there first. Yeah,
even
if all these things are true, dismiss this. And maybe a couple of motions to change venue or to change, like, for instance, if we lose the RICO cause of action, then, I'm going to say I'm going to remove the state court. That's more money the plaintiff has to file, so there's a lot of things that they can do here. But the next line is going to be the answer. They're going to have to answer this complaint. And that's when you'll get to see what the casino and what this other gentleman says, whether it's true or not.
And so they answer the complaint. Typically, is that within 30 days, 60 days?
Yeah, 30 days after they're served. So they'll be served, and then 30 days after that. I'm not sure if it's 20 days or 30 days in the federal system, but here it's 30 days. So they'll be served, and when they serve, they'll have a certain, I think, 30 days to respond. That moves
incredibly fast by our standards here. Like in Quebec, you would have 30 days. You would spend 30 days agreeing on a timetable that would provide when people would do what in the file. That's
oh wow,
that's extremely fast. And then so you file the defense, or they would file the defense before depositions or discoveries, or can they discover before?
This is before, because the only thing the answer is to say do you deny these claims? Because if you don't, and then you'll go through, like you'll sit down and go through each one of these courts and says, I deny these allegations, I deny, and whatever you don't deny, you affirm. So, you have to deny everything. If you don't deny something, you affirm it. And if you affirm it, then, that's the process here. And usually, and sometimes you'll see some of the responses just be a one-liner. We deny all allegations of complaint, and you'll see a motion to dismiss followed with it. So it really all depends.
And so you don't reestablish the facts in the response.
You can say, you can list, like you'll see some complaints that will list, their version of the facts, what they believe happened, that type of thing. Or, but again, the most important thing is to deny the allegations. You want to deny them, because if you don't deny the fraud allegation, then the court's going to say, okay, you've accepted the fraud allegation, and they may give you judgment on the fraud allegation. So you got to make sure you deny all those allegations. That's why.
And I presume you have the same thing. You have deny is drafted, admit. Do you have ignore?
No, it's either affirm or deny.
Okay, so no deny is drafted. If it's drafted improperly, it's deny, and then you'll explain why later.
In your motion to dismiss that you're usually filing with the answer. Here's my thing, and here's my motion to dismiss.
Yeah, see, this is Two Card Arsenal says the California Gaming Board will need to do their own investigation if they are going to find anything. End of story. I do wonder if dismissed or granted, because they're suing for $10 million, and I want to get to that before I forget, but I have a feeling that this might have also just been not a publicity stunt, but rather the impetus to get the bigger bodies investigating, who will do these more thorough investigations on their own dollar and not at the plaintiff's expense. Like, yeah, from a what's the word I'm looking for? From a PR perspective, if somebody files this type of lawsuit and it gets national exposure, if the California Gaming Board doesn't investigate, even if it gets dismissed, if they don't investigate, will they look like they're not taking this type of stuff seriously?
Of course, yeah. And to be honest with you, like when I've had clients who've had these kind of quasi civil and criminal things going on, and if you don't have any money, I say, well, listen, you need to go to the DA's office and maybe speak to them, because if you can get if you want a certain outcome, and if you can get that through the criminal arena, you're not paying any money, you're just telling your story, and you let their lawyers do everything for free, versus the criminal arena where you now got to pay for everything. So, maybe this is a way that you can do both, because don't forget, in the criminal arena too, they'll ask for restitution, pay back the victims their money, and so you can get everything without paying for it if you can go through the criminal statute.
And they're suing for $10 million. This was a question that a lot of people were talking about is, first of all, how do you get to $10 million when he only won $250,000? So in theory, see, from a poker perspective, I can understand how they can, even if he only won 250, the aggregate losses of others could be more than the 250, because Mike Postle may have lost some of his winnings to other players, and it's sort of still a loss for the player who lost the money to him. So if Mike Postle had won, say, $500,000 off the table, but lost $250,000 to another table, the aggregate losses are $500,000, even though his aggregate gain or profit was only $250. I can understand that, but suing for $10 million with no better explanation.
Well, first, I'm thinking that they're equating treble damages. The fact that so that $250,000, but since this is maybe fraud, you can triple that. So you're talking about $750,000, and then you're talking about things like I don't want to say pain and suffering, pecuniary damages, where the court may want to make, not pecuniary, I forget the name of it now.
Punitive or moral damage.
Punitive, yes, where the court may want to make a statement, that, hey, we want to deter this type of conduct. And you have also the pain and suffering and all this other stuff that they can throw out there. To get to 10 million may be a risk, but I think, why not? Why not put 100 million? But again, you shoot for the goal and see what the court comes out with.
That was my only thing with Salmon, was suing for 250 million. I thought the lawsuit would have gotten dismissed just based on the egregious number being asked for, not on the substance of it.
No, you throw out a number. You throw out a number and pray.
It says, why is it that laws are written so complicated? The 10 Commandments were written only on 2 tablets. They're written. It's by design. I made a joke about this in a number of videos. It's by design by lawyers working with legislators so that lawyers can maintain the monopoly on the practice, because if the laws were simple to read, who would need lawyers anymore? and you read through that proceeding. Come now, Veronica Brill, and all these other. The language is comprehensible by design.
Oh yeah.
So let's see what we got here. I think we've done the rounds. Let's see if anyone has any questions now. Get them in before we start phasing out.
And does anybody have any of this groundbreaking information that we've been learning from the side chat? Because I feel like the side chat has made a better case for the lawsuit than the damn thing.
Screaming to my mic. Absolutely. I mean, this is like watching Joe Ingram and watching all these other people. It's like the 4chan investigation where they found the flag that Shia LaBeouf put out in the middle of nowhere based on the cross patterns of the flights of the planes in the sky. You know, this is how you get the information. I do, and it's a crazy luxury that lawyers should have, is to be able to, you know, to go online into these chats and get, if the information turns out to be false, it's false. But man, you can still get some useful stuff.
Oh yeah.
Let's see. Your Honor, please strike those 2 previous checkmates from the court record. This one is the real checkmate. Let's see here. So Nate, what would they need to make this a criminal case?
Well, actually, if you can show the fraud, you may have the fact if he's actually cheating. I would in New York we have something called larceny by trick, where you ever saw those 3-card Monty or on the 3 thing, yeah, and you really can't win the game. You know, you're playing under the assumption that you could win, since you really can't win, they call it larceny by trick. They've tricked you into giving up their money, and that's what this would be akin to. It's a larceny by trick, so that would be criminal. So, but you would also have to show that he was actually cheating. You know, and how do you prove that? I don't know. I think here you have enough to show the statistical anomaly. But that you know, if you take that in front of a jury, they may say being lucky is not criminal.
Well, and before I get to this question, Sassy, Nate, you remind me of I lived in Paris from 1999 to 2000, and there was this place near Montmartre where they had the 3-card Monty guys on the street. And I'm 19 years old. I have no idea where I am and what I'm doing, and I'm watching these guys play, and I see them swindling from this German guy. Hundreds of it was francs at the time. It was like the nice, colorful French money. Hundreds of francs, and they're tricking him, saying, "Oh, you can do it. Pick the thing." And like, I go to the guys like, "Dude, stop doing this. Stop doing what you're doing." And like, these 3 guys come in and elbow me in the stomach and push me away from the guy. And I was thinking, like, in retrospect, how easily I could have gotten beaten up for interfering with their larceny rackets or whatever it is. It's the stupidities of youth that some people get away with unscathed. The sassy 1962. Viva Frei, if mystery evidence turns up, would both of you give your opinions on possible outcomes? I'll give my opinion. I don't call it an opinion. I call it a prediction, because an opinion implies education. Prediction, anyone can predict. If the evidence changes, I'll for sure give a prediction. Right now, my feeling is that he cheated. My concern from a legal perspective is reading this lawsuit. I would be concerned that it would not survive a motion to dismiss, because they'll make all the arguments that we've made here without the benefit of all of the wonderful information on the side that's not alleged in the proceeding. And that's it. I mean, Nate, what do you think?
I concur. I think right now, reading through this, I think the first course of action, the RICO thing, I just don't think they've tied everything together. I think, could you make it possible for fraud against the player? I think you may have that, but right now, you just have a statistical anomaly. You'd have to then show that he was actually cheating, you know, in some way. That this whole, we think somebody else was involved. We think that he was using his phone. We think, you know, that's all tenuous at best. And I think another strong case that they have was the negligence. But that also hinges on whether he was cheating or not. The negligence is, you know, was the system breached? Because right now we don't know that, and they haven't even alleged that. If the system was breached, did they know? So
this is remind me to get back to the question. You know, let's do it first. Criminal investigation. There's a difference between deciding to pursue an investigation and pressing charges, right?
Yes.
So would this be sufficient to conduct a criminal investigation?
Yeah, definitely.
Okay.
Just off the stats alone. Off the stats alone, you can do it. Yeah.
And so then the police can come in and say the police can subpoena records. They can subpoena video evidence. They can say they can go in and get access to whatever they want.
Yes.
So well, the criminal investigation might actually reveal stuff that would help the civil lawsuit in due time.
Yeah.
Okay.
You can get everything from the investigation of where, if you're, if you're a personal attorney, the first thing that you would do is you send out your I forget you'd send a letter out to the other side, a preservation letter, saying, hey, we want you to preserve documents, everything for this course of action. So you'd send that, but then you send it to this guy, a private guy. The first thing, he probably gets that preservation letter, and he's probably throwing his phone away. He's probably destroying evidence all over the place. So you maybe get a negative inference, but again, it's all going to come down to, do you, yes, he's looking at his phone. It looks like cheating, but is it, did they allow people to have phones there? He may say, hey, my daughter's always sending me cheery stuff during while I'm playing. So I always look down just to smile and say, oh, thank you. There could be some excuse he can use. Do I think this guy was cheating? It seems obvious that he was, but who knows? And
so Old Grumpy One says, straight up, would it be worth your time to run in such a case at this point? So, I mean, I assume you mean like to take this type of case up. It's interesting. I mean, this would be one of those cases where you would tell your client right off the bat, we have a massive uphill battle. Your chances of success, I can't give you probabilities, but unlikely. We can take our chances and drop it if it goes south, or hope to strike gold in terms of evidence. But we can file with the best of what we have. Just be sensitive to the fact that it's not a particularly strong case. Nate, what would happen? I mean, it costs. How do I remove this comment now?
Well, the first one. Well, the first one. If they got the RICO cause of action, if you win, you're actually able to get cost for your attorney, because I know we have the American rule, which means each side pays for their own attorneys generally. But I think that statute, for the RICO statute, it allows the defendant the plaintiff to recover cost from the plaintiff. So
and now, if hypothetically, because I don't know how this works, if the plaintiffs just withdraw their proceedings or they desist, as we say in Quebec, would they have to pay legal fees, court costs? Like what cost would they have to incur? A percentage of the amount that they've claimed if they decide to drop the claim?
No, they would just have to pay again, it's the American rule. They would just pay their legal fees, and the other side would pay their legal fees, unless the case was just like so frivolous where the court is like, but I think it happened in the Donald Trump versus Stormy Daniels case, where the court was like, this case is just so frivolous that Stormy Daniels, you got to pay his legal fees because you just wasted our time.
Yeah, that I remember. The big joke was that I think Avenatti or Stormy Daniels had crowdsourced for her legal fees, and then the whole joke was that everyone who donated to her legal fees ended up paying for Donald Trump's legal fees, which was insult to injury to many.
That's just the way it works.
So let's see here. Let's see if we've missed any questions. If they banned phones, he shouldn't have had it on the table. I don't think they banned phones at that particular tournament, because that would have been over the top. I mean, if they banned phones and he was on his phone, that would be good evidence, better evidence right there.
Everybody seemed to be able to have their phone. I think he just used his freedom free. And it's funny because every time I go to the casino, you're not allowed to have your phone at the table. That just doesn't happen. I don't know what casino I want to go to this casino now, but you can have a phone because they tell you first, please, sir, put away your phone, or you have to walk away from the table when you.
Yeah, well, that's the other thing. Is like you're not even allowed looking at your phone when you're not involved in the hand. At least, there's the casino I've been to in Upper New York State, Turning Stone. If anybody knows it, I haven't been there in 5 years, but you can't even. And if they see that you're at the table sitting with too many people that it becomes a problem. Yes,
and you're looking at your phone. Call
big time.
I'm all in. Yeah, come on.
Do you guys think this would most likely settle? I think that if I'm the defendants, I'm not settling. I'm waiting for bad information to come out. If I'm plaintiffs and they offer a settlement, they might just pay to make it go away and deal with any criminal recourse later. But no, this is too premature to talk about settling, because I don't think defendants would think about settling yet.
No. I would throw my motion to dismiss out and see if you can survive that, then we can talk about. But first, you got to survive a motion to dismiss.
El Rojo Grande. This is going to be a subject of one of my vlogs in the future, because Nate, a few people have been asking me what I think about what do they call it in the States? Pro se representation. And I'm not going to make it inflammatory like this. I just think it's never a good idea for somebody to present themselves ever. Period.
But sometimes you just don't have enough money for an attorney. But yeah.
But out of monetary necessity, there's never a good reason to do it.
Yeah.
The vids make it pretty clear. See Ingram's or Berkeley's vids on the device used. Yeah, the evidence is out there. It's thus far it's inconclusive.
Yeah, if you watch, like, if today when I was doing research for this, I watched maybe 3 or 4 different videos where everybody had a different theory about how he was doing it. And maybe the one person was saying that he had an RF reader in his phone. The other person was saying that he had somebody in the back and they were getting signals from the RF chip. The other person was saying that he was able to cut into the live stream. So based on that fact that everybody has a different theory, that means nobody knows what really is going on.
No, exactly. Now, apparently, I think I saw it somewhere out here that the theory is that he moved to the bone conductor hat after the telephones were banned. But again, if that's true, that should have been alleged in the proceedings. I mean, that there was no mention of that. Incidentally, I didn't realize that the bone conductor hat is actually just it actually acts like a headphones. It's not like Morse code like I thought it was, although it could be used that way. But it actually through the bone generates audio into the ears, which is totally.
Yeah, I can see that happen. Matter of fact, let's do a quick poll of the chat. Press 1 if you think this guy definitely cheated, and press 2 if you think he did not cheat. And we'll take a straw poll.
While you do that, I'm going to answer this question. I prepare my own taxes. Do I have a fool for an accountant? Well, I cut my own hair. I may have a fool for my own barber. But yeah, what do we say? One is guilt. One is cheat. Two is not cheat.
Let's
see what happens here. I think yeah, there you
go. Oh man, yeah.
Smart ass Wilson.
So I think everybody believes he's cheating. But now, did this complaint sufficiently allege that he cheats? That's the problem.
Yeah. You know, the funny thing is, if we had seen 1, 2, I would have asked, okay, if you don't think he cheated, would you play poker with him? Yeah, there was not. I mean, we got a good. Wow, there's a good 50 there. It looks like at least. Oh, we got one. Alan Millen says he thinks he's innocent. And I'm curious. I mean, I'm curious to know why. Innocent because not proven, or innocent because you actually just think it's more likely than not that he didn't cheat and he just got not. I don't want to say lucky, but that I feel bad for him because the worst thing is, like, if he is in fact an apostle, if he is a genius poker player and he can never play again because everyone thinks he cheated, that's almost when, if you're that good, you might want to be smart enough to not show the world that you're that good and dumb it down a little bit for the regular poker players. Yeah, no, that's it. I think the circumstantial evidence is overwhelming, but
damning. It's damning.
It requires it's you can have that belief in discussion, but not necessarily in the courtroom. That's the bottom line.
But I do think this is a fact. For the purpose of a motion to dismiss, I think it may survive because I think the fact that the statistical evidence is a fact that could fairly be interpreted by a finder of fact, which is a jury. In other words, does this mean he's cheating 94%? And in the context of most people, let's say most people have a 30% win ratio and something extraordinary would be 50%. He's at 94. Does that allege something? Just like with the roundup cases, just like with all. So I think the statistical analysis could make it, but I think you'd have to maybe put some more context in this particular complaint. The judge would be doing him a favor to move it forward. But if you put a little bit more in this complaint, I think you may have something. You got to tell me, what is the average win rate? You tell me 94% is too much, but you haven't told me what is average, and then what is exceptional based on that number.
Yeah, apparently this is just not even, it's in unfathomable stats. Anyway, we'll see what happens. I mean, it's going to be fun. So now we should then be looking for next steps, either a motion to dismiss or the response.
Yeah, generally they'll come together. It'll be a response, which is an answer, and a motion to dismiss will follow that. And generally it's going to be for failure to state a claim. All this stuff is true, and really, if you accept it as true, can they survive? Can they survive the cause of action? I think the first one may be a problem.
And it would be the facts that they accept as true and not the conclusions. So they would say, okay, we accept the facts that it's statistically improbable. We don't accept the conclusions that it was cheating, but we accept the facts and no claim.
It's possible. I think the negligence may. I think you may still get negligence. You may still get fraud, just based on the statistics. But I've just seen nothing that ties them all together in any type of criminal enterprise. I see that I just as well see this guy just acting on his own in the casino, just being ignorant to the fact that he's doing this, or even how he's doing this.
Yep. All right. I think we agree on that. Okay. And this is now, unless anybody's got any questions that we didn't get to, I think 2 hours is a good time to wind this up. Let's give it 45 seconds for any more questions we missed. But Nate, it's fantastic. I mean, we're gonna have a bunch of themes of live streams and of lawsuits to follow. This one, Smollett, Sandman. I need to know what's gonna happen with Salmon. We've got a lot.
Oh my God, Salmon.
Well, that will be a topic of another stream. We're good with that. Is its own beast right there.
Oh yeah. Oh my God.
Someone asks something stupid. Yeah, that's it. We have to end the live stream anyhow, but at least I think we've done good here. So we're going to follow up on this when something happens. And peeps, everyone, thank you for tuning in. If anyone's got any questions, DM us, email. Let's see. Hold on. Can we get the link for Nate's channel? Stick around while I do this right now. I don't know if you can see what I'm doing. I am
did nothing.
I'm going to go get your thing now. But
oh,
Nate, you want to post your channel to see who does it faster?
But I can't because I can't post it in the live stream. Somebody just type 1.
Okay, so hold on. While we do this, I'll get everyone stick around. I'm going to post Nate's channel right now. I should do that at the beginning. And now my internet is so slow because I'm maxing out our bandwidth. Nate Broady.
But one thing I do want to ask people in the chat before you leave: Does everyone in the chat have by reading through this complaint, have you been convinced that both the player and the casino were in some type of criminal enterprise? Does anybody, is that something that you got from this complaint? Because I didn't get that.
Well, I guess the question is now 1 or 2. Who feels stronger in the case now being 1, and who feels weaker in the case being 2? Let's see what people feel about that. Because it's true. I mean, I read through it, and they're shocking, salacious allegations, but they were not substantiated. It's like, this is what I think, but this is why I think it, or this is the evidence based upon which I think it. I forgot the numbers now. 2 was feeling weaker in the case, right?
Yeah. 2 is feeling weaker. One is feeling stronger.
Yeah, it's a very interesting. Yeah. And it's not to fault the attorneys. I mean, first of all, I think if the attorney had any of the information, assuming the information in the chat here was accurate, if the attorney had it, they would have or ought to have included it. Let's see. I thought the complaint was weak, but I think it'd be enough to proceed. But who knows? Well, we'll see. It's proceeded. It's just going to be a question of whether or not it withstands, what it's going to face. Phil Ivey, edge sorting case is super interesting.
Yeah, I saw that, his edge sorting case. When we were doing research for this, Phil Ivey. You know Phil Ivey? Do you know Phil Ivey?
Yeah, 100%. 100%.
Yeah, he won like $10 million over in London. And doing I forget the name of the game. The Chinese, it's not Pai Gao. I forget the name of the game. But anyway, he won $10 million, and then he came to Atlantic City and won like another $9 million. And he was edging the cards a certain way so when the cards were face down, he could see what they were. And he had but they said that was cheating. So
yeah, that sounds like cheating.
but the thing is that everything he did was legal. Like, he went and told the casino, if you want me to play here, you have to have these certain conditions, and those conditions allowed him to get this advantage. In England, they said, he lost actually in both cases, but he won something like $10 million.
Did he get to keep money?
No, both the Supreme Court of the UK made him give it back, and then the court in New Jersey made him give it back too.
Son of a beasting. Well,
yeah. And he wasn't cheating. His wasn't cheating. He just found a flaw in the game. Baccarat. Yeah, he found a flaw in the game and exploited it. But they were saying it was cheating.
Huh. Oh, very interesting. Okay, I'm going to read up on that just for my own benefit, because I assumed physical manipulation of the cards was in a cheating way, not. Oh, very interesting. Okay.
Yeah, you were able to. There was a flaw in the deck, but now they've seen somebody can exploit it, so now they're not taking no chances with that.
I think the fact that Veronica put forth the complaint to the casino and he did nothing. I wonder if the Gaming Commission will also launch an investigation. I think everyone's going to be launching investigation. Oh, yeah. But it doesn't change much about the lawsuit itself, which is. Let's just hope the lawyer's watching this and goes and fleshes out some of the information for its veracity that has been offered in the chat, in the side chat here.
Yeah, because it seems like the people in the side chat, you guys are keeping all the information from him. You guys got to let these people know, like, he worked for the guy. Come on.
The Supreme Court of the UK is under dubious review, especially under their verdict on the prorogation.
I watched the video. That was a great video too.
Yeah, I learned a ton making that video, and I can see the dangers of activist courts now. And I understand how people are looking at that. The one thing that struck me is that, yeah, they got 11 Supreme Court justices and nobody disagreed. And that in and of itself is an indication of something. I don't want to get conspiracy theorists. Okay, let's wind this up. Everyone, thank you very much. Nate, stick around. I'll talk to you afterwards. And that's the broadcast. Everyone, thank you for coming. See you on the next installment of Saturday Night Livestream. Peace out. I'm going to end this.